watch his exceptional story, Pursuits by Škoda, only on Bloomberg Quint.
Hello and welcome to Bloomberg Quint. You're watching Insolvency Diaries. The latest proposed amendments to the Insolvency and Bankruptcy Code promise to restore the creditor hierarchy, ensure speedy resolution of cases, open up structuring possibilities in resolution plans, and make plans binding on the government and local authorities. To discuss the implications of some of these changes, joining me today is Nilang Desai of AZB and Sudipta Routh of Indus Law. Nilang, Sudipta, welcome to Insolvency Diaries. Nilang, the first key change is a clarification that a resolution plan may now include provisions for restructuring, and that could include a merger, an amalgamation, or a demerger. What was the need for this clarification, and what kind of possibilities does this now open up that didn't exist today?
Sure. So I think the ability to reference the next step of a demerger or merger was always there, and plans did that already. What the statement of objects and reasons is saying is now, with this clarification, you can put in provisions in relation to this as well. So the suggestion seems to be that you can actually put in the active provisions of a demerger or merger in your plan. Now, I think a few things have to be thought about. The timing of that, the feasibility of that. You have only 9 months to run the process. You know, on the one hand, you're doing a resolution plan. On top of that, you have to think about the various consents and processes and timings and stakeholders involved in a future merger process which you want to bring into this. So I think that needs to be worked out. But if it's possible, I think what the law is saying is put in the provisions over here as well. It's the same court. Try and get both consents together, which will be difficult given the practicalities of it. But certainly the possibility is there.
So the plans, let's say, that you have seen haven't envisaged any of these restructuring so far that, let's say, are in the works or probably have come to courts?
They have envisaged it as something they will do,
okay,
but not as a one-stop shop for both the IBC resolution plan and a demerger and a merger.
Okay.
Not that I've seen anyway.
Okay. So, Deepta, are you seeing this as a one-stop shop clearance of sorts for restructuring, sort of that can now be built into resolution plans?
No, not at all. Because what they're doing is, if you notice the wordings, they're saying for removal of doubts. There was actually no doubts that you could put in demergers, bolt-on acquisitions, you could put on amalgamations through a code-driven process. You could do all of that in your resolution plans. There were certain doubts which were expressed by resolution applicants as well as the COCs as to how is this to be implemented. Will the approval of the NCLT of the resolution plan mean that this is whitewashing the entire process under a different statute, which is the Companies Act? The answer is no. You do put in whatever steps you can into the resolution plan. It's for the COC to then evaluate the feasibility and viability, and that language is there in 30, I think. And you're supposed to look at that and you're supposed to say, okay, we could go ahead with this, but we don't believe that this is viable or this is feasible for you to get this consent or that consent. So what they've really done is remove that doubt, in the sense that you can definitely put it in, you can say what you want about it, and you leave it to the COC to make that judgment whether this is feasible, and it's not a one-stop shop, for sure.
Okay, so two questions. One, I can now sort of envisage a merger or a demerger, etc.
Yeah.
Can that process, A, run parallel to the insolvency process? Or two, when let's say I get a stamp of approval from the adjudicating authority on my resolution plan, do I then restart that process of amalgamation, merger, and seek approvals thereon?
Yes, it does mean that when you do go to the court and file a petition for amalgamating a composite scheme for amalgamation, demergers or whatever, that's what you'll usually do. The resolution plans I've been seeing, if they have a demerger, an amalgamation, they try and make a composite scheme. And I've seen a resolution plan which actually has a draft scheme with it. But the point is, you can't go and present that petition without the requisite shareholders meeting, creditors meetings of other entities as well, right? So as long as the CIRP is continuing, and that ends when NCLT says this plan is approved by the COC and here's our order. That's when you go and make the filing. Now, can you get sort of consent from the other shareholder groups, the third-party stakeholders? Yes, you can. There's also been a lot of debate in the IBBI in the last 6 months at least. How do you arrange for pre-packs? Pre-packs has been a bit of a topic in the recent past, where you actually go with a scheme and you say that, here, this is my scheme, and or if you had a JLM in your company before you went to the CIRP, you already have a resolution plan there. You go with that pre-pack, and you say that this is my resolution plan, and all that is pending, therefore, is really filing the petition in the NCLT. And you can't do that because you don't know if your resolution plan is approved until the NCLT passes the order.
Sure, okay.
So that's the sort of trail.
Okay, Nilang, are you also reading it as, what Sudipta explained, that you will need the requisite shareholder approval of the concerned, let's say, a subsidiary that you're planning to merge as part of the resolution plan? You will need to seek separate shareholder approval and the requisite approvals even after the resolution plan is approved as part of the CIRP process?
Of course. I mean, there is no doubt that this is not allowing you to ride over the consent requirements of a third company which is being merged into this.
Okay.
The question is whether the courts will interpret this to say, I will try and do these processes simultaneously. So when you leave my court, you have both. Is that going to be feasible and practical is the question.
So the NCLT wearing the hat of both as a court of IBC and as a court of Companies Act?
Correct.
Okay, all right. The second change has to do with distribution to operational creditors under resolution plans. And in a way, to me at least, it reiterates the way the NCLAT conclusion came about in the SR case, because the NCLAT had held that at the resolution plan stage, financial creditors and operational creditors can't be discriminated. They had said that operational creditors should not be paid less than what they would have received in the event of liquidation of the corporate debtor, but that doesn't mean that they should not be paid more than that, right? Because that they had said would amount to discrimination. Talk to me first a little bit about what is happening as a result of that NCLAT ruling, and then we'll come to the proposed amendment and whether you're reading it as what the NCLAT had concluded.
No, to my mind, I think it's a complete volte-face. I mean, it's a complete reversal of what the NCLAT was suggesting. I think where the NCLAT was coming out was you can't apply the 53(1) liquidation waterfall at all. So if you have a resolution amount to be distributed, you don't say that, oh, you very well secured creditor should get more than a poorly secured creditor, should get more than an unsecured creditor, should get more than an OC. You can't say that according to the NCLAT because this is a resolution. And I think one of the arguments used was, in a healthy company, you could have gone to court and all the creditors would have got the same thing because you'd get that from the court. Now, as it happens, this is not a healthy company by definition. So I think what the NCLAT was saying is take this amount and split it equally amongst all of you, all secured creditors, no matter what the ranking and priority and the value of your security. Unsecured creditors, operational creditors, everyone shares the same amount. What this is saying, and not only the section you're referring to, but a bunch of other sections read together, are saying, one, that the COC, when approving a resolution plan, may in the first place consider how to distribute the amounts under the resolution plan. So it seems to be something now clearly within the remit of the COC, which is something which the Supreme Court had said, if it's within the remit of the COC, it's entirely the decision, courts mustn't interfere. So that's one. Secondly, what the changes are saying is that the COC can also consider the liquidation waterfall in distributing the amounts. Thirdly,
at the resolution plan stage.
At the resolution plan stage. Thirdly, what they're saying is you must keep in account the ranking and value of the security. Now,
okay, I'm going to stop you. I'm just going to stop you there because I do want to come to the point on why you don't agree that in some sense they have partly reiterated what the NCLAT had held, because they've said that the operational creditors should get the higher of the two options. One is either the amount they would have got if the insolvent company went into liquidation, or what they would have got as per the waterfall laid down in the IBC, which is, let's say, your IBC cost dues, your secured creditors, workmen dues, and then operational creditors. So they are sort of setting a base, or let's say a floor, that they at least have to get the liquidation sort of value, or rather that value that they would have gotten if the company was liquidated. Or if you're getting more than that as part of the resolution plan, then don't set that as the be-all, end-all of what the OC is going to get. That amount can be even higher than that.
Correct.
That's exactly what the NCLAT had held.
No, what the NCLAT has said, take the resolution amount, distribute it equally basis the claims. So if I am a secured creditor who's owed 100.
No, I'm not. In the fact situation, you're right. But I'm saying in the principle-wise, what they did say is...
Principle is totally different, Pasani, because what it's saying is, take the resolution amount, string it through the liquidation waterfall, which means that if you're a secured creditor, first distribute at that level, whatever's left goes to the next level, and next level, next level. And if you do reach that lowest waterfall of the OC, then they should get that. So in a situation where the liquidation value of a company is 1,000, fair value is 3,000, the bid is 10,000. It may be that the secured debt is only 8,000, therefore you go down the waterfall and give some more money by way of resolution amount to an OC. That is different from what the NCLAT said. The NCLAT has said if you get 10,000 rupees as a bid, distribute that equally amongst all claims, no matter where they stand in the waterfall.
Correct. It eventually came to the point, but at one point it did say that, okay, I'm not going to sort of belabor over this point. So, Deepta, come in here on, does this sort of set right to some of the sort of concerns that Nilang has voiced in terms of the NCLAT treating the financial creditors, whether they're secured, unsecured and operational creditors, and putting them in the same bucket, because they had held that the waterfall that Nilang mentioned isn't applicable at the resolution plan stage. The section mentions the liquidation stage and hence that waterfall. And now this proposal sort of seems to rectify that position.
Yes, we were all alarmed when we read the NCLAT order, which said that you can't use 53 as a basis of any distribution for a resolution plan, and that was patently wrong, right? So this amendment again seems like a reaction to that as well. If you see the emphasis on section 53 here, they're telling you very clearly that you can use this particular waterfall, and there is no bar against using this waterfall in a resolution plan. What they're then trying to do is they're trying to give you an option where if there's a higher amount, then you pay for it. But I have a far more serious comment on the explanation, and I think this much is pretty clear, but the explanation tends to turn this on its head again. If you don't mind, I'll go into that explanation immediately. Sure. You see, what they're then saying is, for removal of doubts, no one really had any doubts here. Yeah, it is hereby clarified that the distribution in accordance with this provision shall be fair and equitable.
When I say this, when you say this provision, which is the two options that I just mentioned, that the operational creditors should get the higher of either of the two options that we just discussed.
Right. Now, you set this algorithm, right? You put down the math. Now, what do you mean by fair and equitable after this? For me, this opens the door again for litigious claims that this is not fair and that is not equitable, because once you've satisfied the test here, there is no other test. You must remember that NCLT has very narrow discretion in this code, and that's on purpose. We know, even from the Swiss Ribbons case, we know that there is really no place for you to consider crudities and inequities in an economic legislation.
But given, Sudipta, that we have seen case after case, courts taking a socialist approach to say that, look, you're not treating operational creditors in an equitable fashion, they are being discriminated against. To me, it read like just, water-tighting the whole clause to say that, look, once you follow this maths of these two options, then there is no room for you, NCLT, to judge that whether or not this is any more fair or equitable.
What Sudipta is saying is that there are two ways to read this. One is that if you distribute according to the above, it is fair and equitable.
Correct.
I think what he is saying is maybe the interpretation could be that after distributing like this, make sure it's also fair and equitable.
Yes, because the way they're wording this, for removal of doubts.
To my mind, I think the intention is quite clear. What they're saying is if you distribute as above, it is fair and equitable, and therefore you courts now have told you that it's a commercial matter of COC. I've told you how you may distribute it. I've told you how you must give the minimum amounts to OCs and DFCs, dissenting financial creditors. And once you do all that, I think this is fair and equitable is what the
I would have written it differently. I would have said there is no room for any fair and equitable premises if you followed the above. You can't then go and say shall be fair and equitable. If I have a problem, I'm going to say, hey, this is not fair and equitable. You've chosen these two options because there is a third option whereby we could have extracted higher value, and the object of the court is to maximize value for all stakeholders, right? What you've done, financial creditors, because of the preponderance of rights which you have, and because you're able to form your own coteries, you have relegated us to only these two options. How is that fair and equitable? I have the room to ask. And actually there is no room for me to ask that. Because when you play this game and when you're going through this algorithm, everything is set in math, right? After that, and also if you look at the NCLAT order, which is so disturbing, which actually resulted in some of these amendments, it was throwing the entire code off kilter. It was bringing in considerations which never existed. It was bringing in discretion.
Yeah, of course.
I wonder Sudipta might be satisfied if it says shall be considered fair and equitable.
I would have been happy with that. I still have room to argue that they're just clarifying. But when you predicate all of this,
it still hasn't been approved, so I think you have the option to approach the whoever MP you have access to make that case for you in the Parliament.
Well, you have to go to Ms. Sitaram.
Okay, all right. Okay, the distribution to operational creditors that's now proposed will also apply, Nilang, to pending cases. How will sort of that change things? Will people need to go back to the drawing board to sort of now rework their plans?
No, to be frank, I would have thought in a vast majority, if not almost all cases, the formula would still result to OCs getting zero. Because in most cases, secured creditors are taking a haircut. If they're taking a haircut after the resolution amount is put through to them, that means through the waterfall, when you go down to OCs, they're still getting zero. So the higher of liquidation value, which is limb 2, and the resolution amount taken through 53.1, which is limb 1, is still zero. So I don't think it makes any monetary impact.
Okay, so you're saying in any case a liquidation value was coming to be
This
nil.
formula would still give them a zero,
right?
I think, in most cases, almost all cases. So I don't think it's going to have much of an impact.
Okay, the NCLAT had also concluded in the SR Steel case that the distribution of amounts is not a commercial decision, and it shouldn't lie with the COC, it should lie with the resolution applicant. To your mind, does the language now that is proposed sort of address that conclusion?
Look, that premise itself is false, right?
It's false or not, but it was the precedent. Then, I mean, so what I'm asking is that does the change language in the amendment address that?
Not necessarily. The proposition is that, look, there is going to be some amount of parlaying between a resolution applicant and COC. It's not as if, a resolution plan is placed on the table without any conversation with the COC at all. It has to happen. This is a bargain situation. So we didn't see the need for this.
Okay, Nilang?
Well, I think what the language is now saying, all read together, is the Committee of Creditors may approve a resolution plan after considering feasibility and viability and the manner of distribution proposed, which may take into account the order of priority under 53.1 and the priority and value. I think what it's saying is that the Committee of Creditors may distribute in this manner or may permit a distribution in this manner. So I think if the COC is looking at distribution, whether it's proposed it itself or an RA has proposed it, and it's approving it on the basis that it falls in line with this, I think what it's saying is COC is okay to do this.
Okay.
And read with the Swiss Ribbons case, I think we have a lock where the Supreme Court said if it's a commercial decision, if it's a COC decision and a commercial decision, don't interfere. So I think we have a fairly strong case. And I think the theme of the NCLAT judgments has so effectively and completely been reversed over here. I would be surprised if a court goes back along those themes again after such a clear statement from the legislature.
Okay, you've alluded to it, Nilang, but I will sort of just bring this point once again that the COC will also need to take into account the value of the security while sort of making this distribution. Again, going back to the SR case, the NCLAT had negated that sort of premise or that argument, and it had upheld Standard Chartered's argument that, you can't take into account the value of the security, it needs to be done on a proportionate basis. Sort of that precedent also now seems to be getting rectified.
Yes, I think it's back to where we should have been in the first place. I think it's very clearly saying that when you're ordering distribution, you must consider both priority and value. And therefore, if you're a creditor who has, an asset which is security, which is 3x your debt, as opposed to one creditor who has an asset which is security, which is 0.01, then clearly we should get a different amount, is what this is saying. And if you remember, I think about several months ago when we discussed the Binani judgment, I was saying this, which is that the language there was very worrying and could lead to exactly what eventually happened.
Correct.
So I think we've gone full circle. The initial worries from Binani, and then the SRC judgment, and now we're back to where we should have been.
Okay, all right. So, Deepta, let's say, while the Supreme Court is listening to or hearing appeals in the SR case, this becomes law. in the Parliament approves it, will this act as a good solid argument for, let's say, lenders to go back to the distribution that they had originally envisaged in the ArcelorMittal plan?
For sure, because if you look at this slew of amendments here, and if you look at, again, the DNA of this amendment, it's really a reaction to NCLAT. Everything that NCLAT order had said, they're trying to rectify, get it back. A lot of it is really clarificatory. If you're talking about the security value, for instance, he said we'd gone back to where we were, right? It existed, 52 and 53. If you read those two sections together, a secured creditor could have gone outside the process, realized the security, come back. Now that's built into the code, right? But what has happened here is that the interpretation through the NCLT sort of twisted the meaning in the code. And this amendment, this entirety of this amendment, is really to get it back in there. If you look at any of this, this is not really a significant change in the way the code has been drafted. It is more a course correction. It had veered off in a particular direction. It was brought back in.
But the point to be made is how quickly. And I think really the one takeaway I have from all of this is we've done a lot of work to come back to where we should have been in the first place. But really, how quickly has the government reacted? I think it's phenomenal. From judgment to the press release, 13 days. I don't think any other jurisdiction is giving as much attention to any aspect of its policy as I think we are giving to this space.
Yeah, we saw that in 29A as well. We saw that in the rapid amendments that come through, and the dials are, the government's really on the dial on this. So yeah, definitely.
Okay, the one other point that sort of is coming out again as a clarification in this is that the resolution plan will now be binding on central and the state governments and local authorities for any statutory dues as well. What has really prompted this sort of clarification, and do now tax dues waivers get built into the resolution plans, and how does that work now?
I think they've always attempted to, and I think in some cases it went through, the ability to cram down government dues as operational debt. I think in some cases some government authorities fought it on the basis that it wasn't so clear to them. And I think this is effectively clarifying that no, actually, you are also bound, whether you're state, central, local, your dues are debt which can be crammed down. So I think this is welcome because it's easier to point out and say, no, here's where your name is mentioned, sir.
Okay, so Deepta, we were chatting on this offline that let's say there is an outstanding tax amount against the corporate debtor, and let's say there is indirect tax claim from the GST office, and the GST office doesn't even submit it as a claim or as an operational due. How do resolution applicants then build that sort of amount into their plans, or do they need to now go have independent conversations and get tax guys on the table, and is that an exercise now applicants will have to do?
The position is quite different when you look at an operational creditor and tax dues. The first thing you need to be very clear about is the objects in this code. They are very consciously reasserting the fact that crown dues will come far lower in the priority, right? Now, operational creditors, on the other hand, as a matter of strategy, they could sit back and not offer the claim at all. They would wait until the company popped out of the CIRP process, and we don't have a standstill period after the company is refreshed. And at that stage, if you file a claim, and you'll notice that the NCLAT judgment in this matter was right. They told GAIL that, hey, you can go after the resolution plan is put into effect and then raise a claim. Now, by implication, people would think because crown dues are equated with that of the operational creditor, that state taxing authorities or the tax authorities in the country would have the same right. Now, there's a big problem with that, because if you look at it historically, if you look at the winding up processes under the Companies Act, the pecking order was mutilated by enormous number of government liens, state government liens, all supervening over the secured creditor. Now, this is an attempt, again, to tell people that crown dues will still rank as a lower priority. Can the tax authorities go and file another claim after the resolution plan has been put in place? I think after this sort of a pronouncement, and it will be binding expressly, on the state and the union tax authorities, is the government telling the tax authorities that you may not have the same claim an operational creditor has. And whether the resolution applicant must now go and seek approval is a question of what you've thought in terms of deferment or remission in the tax in your resolution plan. That's how I think it's going to pan out.
No, but there could be, Nilang, cases where the company has been contesting that claim. It's not even admitting that outstanding due, is of the amount.
That's a different ballgame. We're talking about contingent liabilities there.
Okay.
I don't think that's sought to be addressed very cleanly over here, at least.
No, I don't think so either, because the moratorium is just a blank period, and then the claim will just come back in the courts again.
That'll revive?
That'll stay there. It will automatically revive.
No, so then is it not in my best interest to say, yeah, tax authority, you are right, but hey, look, now we are building into the plan that you can't get anything.
I don't owe you any money anyway.
I don't owe you
I
money
admit
anyway.
everything you say, but I'm going to pay nothing.
Yeah.
Sure.
Yeah?
Yes.
That's a strategy.
That's a strategy? Okay, all right. I should probably, whoever adopts it, I should get some royalty out of it. Okay, guys, the last point that I want to touch upon is the timelines that, the amendment sort of refers to. They have said that the insolvency process now needs to be mandatorily, completed within 330 days, and this should include the time spent in litigation. The pending cases, they have said, will get, 90 days once this amendment comes into effect. They haven't, gone further to say they automatically go into liquidation, but I'm assuming that that's the effect of it. 330 days, Nilang, how feasible given what we have seen in the last 3 years? And also, you had some concerns on what litigation period can be sort of excluded from this 330 days.
No, I think certainly more feasible than it was when we had only 32 judges, and now with the significant addition to the judge roster, I think that will be, it'll give us a chance to achieve this timeline, I think. But we'll have to wait and see what kind of litigation it is and whether courts look at this as directory or mandatory, etc. I mean, it does say it's mandatory, but we'll wait and see how courts interpret it. No, I guess what I was saying earlier, Paswani, is that what it's saying is that the CIRP period must end in this timeline. The CIRP period ends when a resolution plan is approved by a adjudicating authority or the NCLT, which means that after it's approved, if there's ongoing litigation, I don't know whether that is curtailed by virtue of the 330-day diktat.
So if I were to take the example of SR Steel, after the Gujarat NCLT approved the ArcelorMittal resolution plan, all of that which has happened after that needs to be excluded from this 330 days?
Well, as long as that, if you were to take an analogous example now, as long as that NCLT approval came in within 330 days, I think it'd be fine. The fact that that plan was then challenged further to NCLAT and then Supreme Court, I don't think is an issue under the 330-day guideline. I don't think that means that you'd have to go into liquidation because you have finished the CIRP in 330 days. The fact that after finishing the CIRP, someone has challenged the finishing of the CIRP, I don't think that's the issue here.
Sudipta, is that how you're reading it as well?
Well, yeah, it's a good way to look at it because the CIRP wouldn't finish if there was an attendant litigation stopping the CIRP itself. And what the amendment is telling you is, okay, go ahead, do all of that, but 330 days is all you have. And that's the experience we've got from the 600 plus issue with SL, right? So anything that comes after the CIRP is obviously not included in this. That is a different thing altogether because once the CIRP is done, you've either got the resolution plan approved and an order passed by the NCLT or it's gone into liquidation, right? There is no other option there. So it doesn't matter. Any litigation that we're talking about here is going to be only that litigation which held up the CIRP. So what the amendment's trying to tell you is that finish all of that in 330 days max.
So essentially...
So warring bidders between, before...
29A, is this guy even... qualified, this is not fair and equitable, that's going to come up a lot.
So it's certainly very, very helpful because it certainly get to a point by which your plan is approved by NCLT in 330 days. That's very helpful.
But it could continue to get litigated post that and it doesn't mean that you have to go into liquidation. Should they now specify post-approval timelines as well?
It's clear. I mean, there is no doubt at least in how that's going to pan out. So any other addition to that would just be a very prolix sort of a draft.
Okay. Final words then. How effective do you think this would be immediately as soon as this comes out? And since the NCLAT ruling in SR has almost been reversed, big relief for lenders and let's say applicants as well?
Certainly the lenders. I mean, at the end of the day, for the applicant, he's giving the same amount of money no matter who takes it. I think lenders will heave a huge sigh of relief. And not only lenders who invested in Essar Steel, but lenders who are lending fresh money today. Do they take security? Do they not take security? Does it matter? Will they get the same thing in CRP? I think those were questions which they did not want answers to. Now they don't need answers to.
Well, we'll leave it at that. Nilang, Sudipta, thank you for joining me here on Insolvency Diaries. The amendment bill is already tabled in the Rajya Sabha and is slated to be passed in this session of the Parliament. Thank you for joining us today, and we'll see you next week.